Namaste, friends, and Suswagatam, and welcome to our Saturday edition of Legal Words of Wisdom, Nyaya Gyan Ganga, on our Virat Hindustan Sangam social media channels, which we beam every Saturday at 8 p.m. Indian Standard Time across the globe. And as usual, we have our Virat Hindustan Sangam patron and president, Dr. Subramanian Swamy. And with him, we have Dr. Venkat Iyer, barrister from UK, who is familiar and has been a lawyer from India and now based in the United Kingdoms. And he has been conducting this program for the information and knowledge for the common man, the legal words of wisdom. Today, as you know, is our episode number 11 in our series of imparting knowledge to our viewers. And today's topic is going to be a very interesting topic: contempt of court, myths and reality, part one. We'll be having two parts, and today's part is one of the part one of the part two of the part two episodes. The contents of today's episode will be: how far can a person go in criticizing the courts? Are judges immune from criticism? Are there any limits on what the media can say about pending cases? What is the purpose of the law of contempt of court? Should people be scared of contempt proceedings? What about misbehavior of judges? Can judges themselves be charged with contempt of court? These are some of the issues that will be discussed in today's episode. As you know, we have the words of legal words of wisdom and what we call in Hindi as the Nyaya Gyan Ganga on Saturdays, and we have a regular program on Sundays at 8 p.m., both at 8 p.m. So, with this, we are starting today's program. It will be over to Dr. Subramanian Swamy for his opening remarks, and Dr. Venkat Iyer will then have a detailed discussion on today's topic. So, welcome, Dr. Swamy and Dr. Venkat Iyer. I also thank our my co-host Ramesh Swamy and also the technical team led by Ashish Shetty, Vishal Mehta, Ishwar Iyer, Rakesh Gadgi from Bangalore, Tejas from Pune, and Swaminathan from Chennai for putting this program and the background team helping us in beaming out this program to you every Saturday. Over to Dr. Swamy.
Well, thank you, Jagdish. I think today I'll have a different format. I'll go straight to Venkat Iyer and ask him to make his submissions and his lecture to the uninitiated as to what this is all about. And then I think when he's finished, I will add whatever he's left out, because I've been finding that he's so thoroughly prepared. There's no need for me to make introductory remarks and put the goalposts for him. And so I'll wait till he completes and then I will intervene in the matter. Over to Venkat.
Thank you, Swamy. Yes, I would certainly welcome your inputs towards the end of our discussion. Now, contempt is an area of the law about which I think there's even more ignorance and misunderstanding than defamation. And this sadly extends to judges as well, at all levels, as I hope to be able to show in the course of this talk. The consequences have been devastating for civil liberties. Contempt of court has, as you know, been in the news a lot of late, and there have been some particularly troublesome cases, including a few which are yet to come up before the courts. I shall refrain from discussing those cases, not because they cannot be discussed under the law. They most certainly can, contrary to the scaremongering that goes on under the name of sub judice, but because I believe that some self-restraint and courtesy is advisable in these matters. And it would also be more productive to analyze cases after they've been decided rather than before, unless, of course, there are compelling reasons to depart from that rule. For the sake of completeness, I should add that there is also a case pending in the Supreme Court in which the constitutional validity of the main law on contempt has been challenged. The one thing I'll say at the outset is that this is a topic which uh, involves a discussion of a lot of cases. Some of those cases require an elaboration of their facts for a proper understanding of them. And this means that I'll spend a little more time than usual, but I can assure you that most of the cases, I would say all the cases, are absolutely fascinating. In order to do justice to the topic, I have decided to split the contempt sessions into two, and I'll also be talking about contempt next week. The first question that arises is, what is contempt of court and why is it there in the first place? The starting point for an answer would be to look at contempt as one of the limitations placed on freedom of expression. So, if you look at the Indian Constitution, it states clearly in Article 19.2 that the state may restrict free speech on grounds of contempt. I'm, of course, paraphrasing. Crucially, any restrictions imposed must be reasonable, which is a point that must be kept in mind at all times, particularly when we discuss cases. In very broad terms, the concept of contempt involves any speech or action that is likely to interfere with the administration of justice. And therefore, this area of the law requires a balancing of two competing interests: freedom of expression on the one hand and administration of justice on the other. And the balancing has to be done sensibly and sensitively. Now, what does interference with the administration of justice mean? There's a lot of guidance given in statute and in case law. Interestingly, unlike defamation, contempt in India is governed by codified law in the form of the Contempt of Courts Act 1971. But this law should be read in conjunction with case law, including from England and other common law countries. It is also relevant to keep in mind two provisions in the Constitution, Articles 219 and 142, which give the Supreme Court the power to punish for contempt of itself. The Contempt of Courts Act defines contempt in a lengthy way, and I'll not bore you with the details. Suffice it to note, first of all, that there are two broad types of contempt: civil and criminal. This division is not quite the same as the general distinction that I've drawn many times between civil and criminal law. So please keep that in mind. Civil contempt essentially consists of willful disobedience of court orders or processes, or willful breach of undertakings given to a court. Note the word willful, which means that accidental or unintentional acts will not be covered. Generally speaking, civil contempt has not been the cause of major problems over the years, although this branch of the law has generated a lot of case law, and it is not uncomplicated. What has been really problematic is criminal contempt. The law defines this as any act which either scandalizes or lowers the authority of a court, or which prejudices or interferes with a judicial proceeding, or which obstructs or interferes with the administration of justice in any other way. I've, of course, simplified the definition to make it easier for lay people to understand. And I should add that the law also covers acts which tend to do any of those things. The next point that needs to be made is the most important one in the entire discussion, namely that contempt of law, a contempt of court, is intended to protect and preserve the authority of the courts, not the individual reputations of judges. I cannot stress this point enough because this is the single most misunderstood aspect of contempt law. You'll hear phrases like majesty of the law or dignity of the law being used, but they are closely related to the authority of the courts. To put it another way, the reason why contempt law exists primarily is to preserve the public's confidence in the judiciary or in the administration of justice more generally. Any attack on the individual reputation of judges will have to be dealt with through defamation law. Now, so low have standards fallen in the Indian judiciary that even the current Chief Justice of India does not appear to have understood the importance of this simple point. I say this with a full sense of responsibility because just a few days before assuming his office, he gave an interview to a TV channel in which he made remarks that are as ill informed as they are worrying. And since I don't want to be accused of misquoting him, I have those remarks printed out on a piece of paper from which I shall read out. He first said, criticizing the judge and not judgment is defamation. Wrong, even if we ignore the grammatical incorrectness of that statement. He then went on to repeat, equally absurdly, criticism of judges instead of their judgments, including on social media, is actually an offense of defamation. And I have emphasized the word offense. Now, he seems to have brought in criminal defamation in that sentence. Moving further, he's reported to have said, they, that is social media, are not only scandalizing but tearing apart people's reputation and judges' reputation. The introduction of the word scandalizing seems to suggest that he was thinking of contempt. Whatever is the case, he was completely muddled, and that is not what you would expect of the Chief Justice of any country. The confusion between contempt and defamation has serious consequences. Among other things, those sued or prosecuted for defamation have many more defenses than those charged with contempt. Also, the scope for cross-examining the complainant in a contempt case, that is the judge, is almost non-existent, while in a defamation case, such cross-examination is possible. Besides, there are a number of other handicaps that those charged with contempt face, and I'll try to deal with those a little later on. A leading case on the difference between contempt and defamation in India is a case called Brahma Prakash Sharma and the state of Uttar Pradesh, which was decided by the Supreme Court in 1953. This concerned a resolution passed by a bar association sharply criticizing two judicial officers as incompetent, overbearing, and discourteous to the public and to lawyers. The office bearers of the association were convicted of contempt, but when they appealed, the Supreme Court overturned that conviction, holding that they may have been liable for defamation, but there was certainly no contempt. An interesting aspect of the Sharma case was that the then Attorney General, Motilal Setalwad, actually supported the appellants, arguing that even if an act was calculated to lower the authority or dignity of a judge, it would not amount to contempt as long as it did not obstruct or tend to interfere with the course of justice. An even more famous case on this subject is an appeal that the Privy Council decided in 1893, wherein the Chief Justice of the Bahamas had been severely criticized in a newspaper by an anonymous letter writer who was extremely acidic and sarcastic. He had suggested, among other things, that the Chief Justice was incompetent and a shirker of his work. He even insinuated that it would be a providential thing if he were to die. Yet, the Privy Council said there was no contempt. At best, the Chief Justice could have sued the letter writer for defamation. The Privy Council, remember, it's a colonial court, said in the same vein, in many other cases, that a distinction needs to be drawn between contempt and defamation. including in one case from India called Devi Prasad and King Emperor, which was decided in 1943. Now, there are many rules about the use of the contempt jurisdiction. Firstly, that the power of contempt must be used sparingly. Secondly, that it must only be used in cases involving extremely serious attacks, which are likely to shake the public's confidence in the judiciary. Thirdly, that it must only be used where the case for the prosecution has been made out clearly and beyond reasonable doubt. Fourthly, no judge who has been affected by the criticism should hear the case. Fifthly, the accused person must be given a fair and reasonable opportunity to defend himself, as well as a chance to tender an apology. And finally, if the apology is tendered in good faith, then the court has a duty to accept it and close the case. I want you to keep all these principles in mind as I take you through some cases. There are various circumstances under which contempt can arise. First, what is called contempt in the face of the court, for which the judges have the power to punish summarily, that is, on the spot, without any trial being held. This type of contempt happens inside or very close to a courtroom. An example that will be familiar to Indians is where a litigant who loses a case gets angry and throws his shoe at the judge, sometimes in addition to hurling abuse as well. I understand that this once happened in a case which was being heard by Justice Hidayatullah, who went on, of course, to become Chief Justice of India. Apparently, the judge very calmly asked his court staff to return the shoe to the litigant, saying, "He has lost his case. I don't want him to lose his shoe also." Nowadays, more commonly, this kind of contempt happens when people forget to switch off their mobile phones in court, with the result that proceedings are disrupted when a phone rings unexpectedly. I would say that most of the time the judge simply lets the offender off with a warning. Interestingly, there have been a few occasions when the mobile phone in question belongs to the judge. And that, of course, results in a deep red face on the bench. But I shall give you an amusing story of a contempt in the face of the court from England. This happened in 1975 when a young man called Stephen Balog, who was training to become a solicitor, had to attend a long trial as part of his training. He got bored, and one day he decided that he'll make things a bit lively by secretly introducing some laughing gas into the courtroom through emptying a canister of nitrous oxide into the court's air conditioning system. To his misfortune, he was caught by the security guards before he introduced the gas, and he was duly charged with and convicted of contempt. And this, of course, is contempt in the face of the court. Now, remember that if his plans had succeeded, there would definitely have been obstruction of the proceedings. But when he appealed, the appeal court let him off, arguing that action should only be taken in very rare cases where a disturbance was actually caused in court. Such leniency is not shown in India. Some years ago, I heard of a situation in which a judge in a lower court somewhere in Maharashtra had made a witness who had come late to the court by a few minutes stand on one leg for as many minutes as punishment for his lateness. Most people will recognize this as nothing but a desire for vengeance, even judicial sadism, which is, of course, not the purpose of contempt law. There is also the ego factor, which comes into play frequently. Let me give you two examples from India. Many years ago, I read a newspaper report which said that a certain High Court judge called I. M. Kudusi from Allahabad had held court on a railway platform in Delhi and punished an official with contempt after the official had denied him a sleeping berth on a train. Even by Indian standards, this appeared to me quite staggering. But I decided to keep an open mind and investigate. because I know that the quality of media reporting in India has also fallen sharply over the years. So I phoned the judge, who was surprisingly very eager to discuss the case with me. His version of the incident was that the railway official had been drunk and that he had misbehaved with him. Whereupon he said he had, as a last resort, revealed his identity and threatened the official with contempt. Now, that version was plausible, and I was willing to give the judge the benefit of the doubt, especially because it's not uncommon in India for government officials to behave in a high handed manner towards ordinary folk. But many years later, I discovered that the judge in question was a notorious character. So notorious, in fact, that he had himself been arrested, as it happens for corruption. That made me wonder if the story he told me was at all true. A second case involving a situation of "don't you know who I am" happened more recently in Kerala. This resulted from a High Court judge called P.D. Rajan, who visited a temple away from his normal place of residence and in Mufti. On reaching the temple, he summoned two policemen who were standing nearby on duty to his car, and he ordered them to go and fetch a lady doctor who was working in a temporary clinic at the temple. When the policeman asked Rajan politely for his name so that he could give that information to the doctor, Rajan refused and arrogantly reiterated his command, saying that the doctor would know even without his name being mentioned to her. It turned out that the doctor was his own wife. But the policemen knew none of this, nor did they know that the person whom they were in conversation with was a judge. Throughout the conversation, they addressed him, as is customary in Kerala, as Cheta, which is elder brother, a bit like Bhai Sahib in North India or Anna in Madras. But Rajan took deep umbrage, considering it to be not sufficiently respectful. The policeman also told Rajan politely that he would have to go and fetch the doctor himself. This angered him, that is Rajan, and he proceeded to take down the badge numbers of the policemen. And the next thing that happened was that the policeman received summonses to appear before him in the High Court a couple of days later. Rajan then berated them for misbehaving at the temple and forced them to sit in a corner of the courtroom for several hours and to copy down a chapter from the police manual relating to a constable's duties, which was described in the news reports as an imposition. Now, conduct such as this should make anyone's blood boil. But such is the state of justice in India that the policemen had to suffer their humiliation in silence. The punishment that they were meted out had no basis in law because it was a judicial order, and unfortunately, it could not be dealt with on the administrative side of the High Court. The same judge, incidentally, was in the news shortly thereafter when, like a common thug, he threatened the station house office of a police station where two of his relatives had been detained for assaulting a security guard at a government hospital. And he told them that unless the duo were released and their names taken off the case records, he would bash them up and ensure that the policeman was rendered jobless. The last I heard about this incident was that the Supreme Court had been informed about Rajan's misbehavior, but I don't think any action was taken against him. He has since, I understand, retired from the judiciary. Now, what possible faith can the ordinary citizen have in the legal justice system if incidents like this are treated as lackadaisically as they usually are? I would submit that one very important is, if I would call an uncomfortable truth behind such a situation, is really the precipitous fall in the quality of judges in India during the past 5 decades. The Hidayatullahs, unfortunately, have been replaced with the Kudusis and the Rajans of this world. I'm reminded of the title of a book that Ram Jethmalani wrote some years ago, Big Egos, Small Men, which encapsulate the situation very well. Next, I want to turn to the form of contempt, which is called a trial by media. I'll reserve the more juicy form of contempt, namely scandalizing the judiciary, for the next session, because there's so much to be said on that subject, but not enough time today. I'll also incidentally be talking about an important amendment that was carried out to the law in 2006, which allowed truth to be used as a defense in contempt cases. So, what about trial by media? It's a catchy phrase and it has profound practical implications. In every civilized society which believes in the rule of law, anyone who is accused of an offense is, of course, entitled to a fair trial. This means, among other things, that only the circumstances relating to and admissible evidence are to be considered by the judge, not anything extraneous, such as the accused person's previous conduct, although, of course, previous conduct and, in particular, prior convictions will become relevant at the time of sentencing if the person is convicted. At the same time, there is another important countervailing interest in all free societies, and that is the right of citizens to know about the administration of justice, which includes information about court proceedings and which also crucially includes the freedom to discuss, obviously within reasonable limits, cases of public interest. How to balance these competing interests has always been a challenge in open societies. The general rule is that cases can be discussed in the public square or on the mass media, as long as the discussion is unlikely to put such pressure on whoever decides cases, which in India, of course, would be judges, and in countries like England, either a judge or a jury, so much that their objectivity is impaired. Now, how much pressure is tolerable depends to some extent on conditions prevailing in a particular society. Generally speaking, I think it would be fair to say that Indians are more excitable than, say, the English or the Japanese. And so the line is drawn differently in India than in England or in Japan. Drawing the line is not easy, but Parliament, or usually the courts, are trusted to perform that task. What should be prevented is mass hysteria, the lynch mob effect, which will make a fair trial impossible. In this context, if you look at the Contempt of Courts Act of 1971, it says that anything which prejudices or tends to prejudice judicial proceedings would be contempt. Let's look at a few examples. The one that is frequently cited in India is the Arushi Talwar case, where a young lady had been murdered with her own domestic servant in the house in which they lived. I understand
along with the domestic servant.
I see.
Not by the domestic servant, but along with the.
Oh, the person who also was murdered was a domestic servant. Is that right?
Yes.
Right.
Yes.
So the case was, of course, quite sensational for that reason. And I understand that media comment on the case was ferocious, with most commentators asserting with absolute conviction that the girl's parents were the murderers, despite the evidence being either very slim or non-existent. The police apparently aided and abetted the media hysteria, with one very senior police officer making patently defamatory allegations about the parents even before the trial had begun. I also understand that many newspapers produce reports each day anticipating the court proceedings that day. Despite all this, the accused parents were ultimately acquitted by the Allahabad High Court, which I was told was seen as a bit of a miracle given the pressure that was put on the court. There was another case in Delhi that I read about.
May I interrupt you here?
Yeah, sure.
Subsequently, there was such a public furor, and it went to the Supreme Court. Supreme Court ordered a retrial, and then
Yes.
the parents were convicted, and they are now in jail.
Oh, I see. Okay. I must confess I missed that. I do know that there was an appeal in the Supreme Court, but I wasn't aware of the conviction.
The CBI reversed its stand and made them accused, the parents. And
Thank
the
you.
parents were so enraged by seeing their daughter having sex with the servant, and that's what led to the murder.
I see. Well, thank you for that clarification. And I was talking about the other case in Delhi, in which a young man was accused of sexual harassment by a woman who apparently went on to publicize his picture on social media. For many months both before and during the trial, the man was apparently vilified, being called a sexual pervert, the predator of Delhi, etc. But it turned out that she produced no evidence to substantiate the charges, with the result that the man was acquitted, but only after 4 years, during which time he had lost his job and he couldn't find alternative employment. But there's another side to this coin which also cannot be lost sight of. It has to do with a myth that is perpetrated by many, that as long as a case is pending, no one should comment on it. That would be just as wrong as media hysteria. In the two cases I just mentioned, there was a genuine public interest in what had happened, so they needed to be covered. Not only is it acceptable for court proceedings in cases, however sensational, to be reported, but a certain amount of discussion of the cases is also permissible. What should not be done is to prejudge the outcome of the case in such a way that it has the effect of putting undue pressure on the court. In India, of course, it is only judges who hear and decide cases, unlike in countries like England, where juries are also involved. The risk of influencing juries is much higher than it is influencing judges. And that's the reason why the sub judice rule was put in place. This rule should therefore be applied more loosely in India. The tendency on the part of people to use the sub judice rule as an excuse to prevent information being made available to the media or to the public must, I think, be strongly resisted. Incidentally, juries themselves can be held guilty of contempt in certain circumstances. For example, they're not allowed to discuss a pending case with anyone other than their fellow jurors. They're not allowed to make inquiries about the past criminal record of accused person. And this means that they should not carry out research about the backgrounds of defendants on the internet. Crucially, they're not allowed to give media interviews even after the case is over. Now, the last rule has been breached a few times, and we had the rather amusing example many years ago of a jury in England using a Ouija board to reach a verdict after it failed to do so in the normal way. Now, a Ouija board, incidentally, is a contraption that is used in a parlor game. And those who believe in it say that it has the power to communicate with the spirit of dead souls. Mumbo jumbo, really. In the particular case that I was talking about, a consultation with such a board apparently indicated that the defendant was indeed guilty of the murder, so he was convicted. But after a newspaper came to know about it, it publicized the story, and the conviction was set aside and a retrial ordered. If you thought such weird things only happened in India, you now know that that is not the case. Can a judge himself or herself be guilty of contempt? The answer is yes. And we have a fairly recent example in the form of the former Justice C.S. Karnan, whose case
Yes.
is extraordinary by any standards.
Yeah.
I plan to talk about it next week when I'll also be talking about other forms of contempt, including scandalizing the court, which has thrown up a lot of both disturbing and amusing cases. To wind up today's discussion, then, I would say that contempt law has been misused a lot in India, but there are occasional rays of hope. For example, just 4 days ago, a judge in the Bombay High Court, with a rather striking name of Sambhaji Shivaji Shinde, pointedly observed that the judiciary must not waste precious time on contempt hearings which can otherwise be utilized to hear important questions of law. One can only hope that such enlightened attitudes spread far and wide within the system. I think I'll stop there. Thank you.
Thank you very much. You demystified the contempt law, and of course, as you mentioned, it'll take a little more time because you know so much about it. Let me just summarize what you said in the way I think where people would find it also an additional aid to their understanding. First of all, the contempt law arises from the enabling article of the Constitution, Section 1, Article 129, where it clearly says that the judges have a right to themselves. If I can read it out, it will be this: that 129 says, Supreme Court shall be a court of record. That's not relevant here. And shall have all the powers of such a court, including the power to punish for contempt of itself. So it's I don't think there's any worthwhile challenge that can be made to the contempt, because the Contempt of Court Act of 1971 flows from that Article 129.
Yep.
But you did mention this 2006 case just now in the course of your. That case, in fact, arose because of me.
I see.
Because for a change, I filed a contempt petition. Because I had made allegations against Mr. Ramkrishna Hegde about land grabbing for his son-in-law. And so Rajiv Gandhi heard about it, asked me for materials, and then he set up a commission inquiry headed by a Supreme Court judge called Kuldeep Singh. And that commission found him guilty. And it's already on telephone tapping. I had made the party pass, the Janata Party Parliamentary Board, of which I was a member, pass a resolution asking Ramkrishna Hegde to step down, and this was devastating. He had a great admirer, the editor of Indian Express by the name Arun Shourie.
Oh, yes.
So he wrote a nasty interview and made a lot of fun of the judge, that is Kuldeep Singh. So a lot of judges themselves told me, this is not fair that editorial like this should come, and you should file a contempt petition. So I filed a contempt petition. And Shourie's lawyers then argued that they have a right for showing that it's the truth, what he said in the editorial. So the right to adduce truth to evade contempt was for the first time heard. And I myself was in favor of that. So although I prosecuted Mr. Arun Shourie, but when the court asked me, would you be in favor of Mr. Arun Shourie being given an opportunity to argue the truth of the matter? And by then, of course, a sea change in politics had taken place. And I was of the view that Mr. Hegde had gone, he had died also. And so I thought that this will be a salutary thing, and therefore I agreed. And that's how the judgment came in 2006, that you have a right to adduce proof to defend yourself on contempt. So contempt has now been considerably weakened.
Yep.
Now, the real question is that there has to be a contempt petition because the judges are defenseless in a sense. They gave a judgment, weighing the pros and cons, and it's always not black and white. There's shades of gray. So their reputation should be protected. And so just wild allegations, he has taken money, for example. You see, that's very easy to make, and it's also, given the nature of the situation in our country, it's also credible. But at the same time, I know lots of very good judges. Chief Justice now Bobde, whom you found his press conference somewhat distasteful. I found him in court, when he sits in court, he is brilliant, absolutely brilliant. And so you should moderate your opinion about him, keeping this view that, go in a press conference, you're now not in a court-like situation. And so you don't have to be like a judge. You can say what you like, I suppose. I mean, that's my way of looking at it. But as far as he gave me the path-breaking judgment on the temples being taken over by government, and he said they can be temporarily taken over for rectifying the financial situation only, nothing else about the temple, and they must return it in a short time after fixing the mismanagement. It's a landmark. It's a Savanagar temple, that is the Nataraj temple in near Kadalur, called Chidambaram, town of Chidambaram. So we released it. DMK has taken it. DMK's lifelong commitment to this Dravidian politics was that we will take over the Savanagar temple and demolish it. And so it was a fight between Hindutva spokesman, myself, and the DMK non-believer. And it was really ferocious battle. But along with another judge, another very brilliant judge, Bobde wrote a judgment, which is now helping us to lead. So anyway, that's a side issue. But I do think this sub judice is a way of terrorizing people or evading or giving answers. In Parliament, they use sub judice. I have to explain how sub judice. You have a jury, as you have yourself pointed out, a jury, and they have to give the decision, and the judge just sort of is a regulator of the proceedings, an advisor on occasions. Whereas in the Indian system from 1956, we don't have a jury system. So when the original idea was that when anybody of great eminence outside the court says that this man is not guilty, unfortunately, he has been dragged to court, that if it appears in the newspaper, will influence the jury, because they are all ordinary people taken by, they open the telephone directory and select the jury. Jury is not selected because they are experts. They even have motor mechanics and sweepers and all that kind of people in England. It. So therefore, sub judice is a thing that is defensible in, say, England or United States, where you have a jury. But where there is only a plaintiff and a respondent and a judge, and somebody outside the court says this is a bogus case, who's it going to influence? It can't influence the plaintiff, because he filed the thing. He's going to fight like hell to see that he wins. It can't influence the defendant. And you certainly cannot say it is going to influence the judge, because that would be contempt. Because the judge is supposed to be above all this. And when he gives a judgment, it is an impartial judgment. So therefore, I think this sub judice we don't need in India under any circumstance. And I remember when I was arguing the 2G case, Mr. Chidambaram's lawyers argued that I have violated sub judice because I am holding press conferences after every hearing of the court, because all the press is there in the Supreme Court, and they take my press conference there itself. So Justice Ganguly asked me, Dr. Swamy, what do you have to say? I said, I have to say there's no such thing as sub judice in India. So he said, can you explain? And I explained that who do I influence by making this statement into the press? Not you, Your Lordship, not Mr. Chidambaram. He's impossible to be taken away from the path he has been following, and nor myself. I mean, I'm making it, so there's no question because I was the lawyer. So sub judice is a weapon that is used to evade giving answers. In court, for example, what's your government stand? Sub judice. I mean, you are a party. Why can't you tell what your stand is?
Yep.
So this otherwise is contempt. So that then finally, I really want to know from you do you think that truth is a defense in a contempt? Because that means the contempt proceedings can go on for a long time. And they may lead to collateral damage by bringing out truth about some other aspects of the judge, which may not be relevant. That is a divorcee. How can he decide on a marriage case? So something like that, All kinds of irrelevant things are there. That's done in cross-examination, that. The main matter is maybe anything, but they will bring in all the other things, whether you've been jailed for traffic violation, everything is brought in. So I would think that the criminal law says that amongst one of those 10 things that are listed in the criminal law for defamation, that truth, if it is in the public interest, should be permitted. I mean, it is a defense. Otherwise, truth is not a defense in criminal defamation. This is what I wanted to say. But anyway, you covered very nicely a lot of ground, and I'm sure that those who are watching would have, come to get the thing demystified. And I will look forward to your next lecture. Over to you, Ramesh.
So, Dr. Swamy, just a quick update on the Arushi case. You are right that they were convicted by the CBI court in 2013, but they were let out again in 2017 by the Allahabad High Court. The CBI has now challenged it in Supreme Court, but the Talwars are out. They have been acquitted in 2017.
In appeal against the criminal,
So it was only in 2008, I think they got acquitted, which the CBI court in 2008.
They said the servant and the girl.
That's the case. But they were acquitted. CBI jailed them in 2013.
And there was a big public furor. Therefore, the court asked the Sessions Court to re-examine the thing. And they found the parents guilty.
But after that, the Allahabad High Court had...
That's a High Court.
Allahabad High Court acquitted them.
Do you know what happened in appeal in the Supreme Court?
The Supreme Court case is still pending. That's what they say. That's what they...
I'm not sure. Anyway, it doesn't matter. But
okay.
Yeah. Ramesh, that was my understanding as well. So what happened was that they were, after a lot of discussion in the media and elsewhere, they were definitely acquitted by the Allahabad High Court. What then happened was, as is possible in India, an appeal was filed in the Supreme Court. Now, I don't think, I could be wrong, but I don't think the Supreme Court has decided that appeal. That appeal is still pending. And the parents are, of course, out because they were acquitted. That acquittal stands. And so, unless it is overturned, they are unlikely to go to jail again. By
far the most... I think you're right. The media trial, I think Arushi was, by far, is the number one. Even today, one TV channel or the other, or a movie is being made out of the same thing. That that's still going on, though. I mean, the trial for Arushi is still going on in multiple formats, sadly.
Media pressure has not only made a retrial for this Arushi case. So they held the servant, who then later on was supposed to have committed suicide or whatever, but that he was responsible for killing her. And then the media pressure made the case to be reopened on the direction of the Supreme Court. And that the Sessions Court found them guilty. That they went to High Court, it's escaped my memory. But I thought that they are still in jail. But anyway, we could have come out on bail after the case. Even if they have been acquitted, once it appears in the Supreme Court, I don't know what happened. And anyway, next time I'll tell you.
Yeah.
But I'll give you another case where the media may have committed contempt, but they managed to get the killer convicted and sent for years to jail, son of a very prominent congressman. And that is that bar lady, forget her name. She was,
Jessica Lal.
Jessica Lal case. So there was a huge media thing. Who Jessica? No, what?
Who killed Jessica Lal?
Nobody killed Jessica Lal. I mean, she was killed because the boy shot her point blank range, and because she declined to immediately serve him a liquor drink. So the pressure, and it was the police had closed the case, saying there's nothing in it, and then the public pressure made it being investigated, and then the boy was convicted. I think he must have spent 10-15 years on jail.
I think Venkat was replying to some point, I think.
Yep. Can I just, it's a very brief point, in a sense, reiterating what Swamy said, because Swamy, at one point, I thought, posed the question to me. So I'll just reply to that question. It is true that the point about public interest has been considered, and it has now been recognized in law. So what happened was the 2006 amendment to the Contempt of Courts Act specifically says that truth shall only be a defense if it is coupled with public interest. And I want to I was planning to discuss it in the context of a case called the Gadkari case. Madhav Gadkari, who in a sense was the trigger for that particular amendment, in addition to, of course, what you mentioned in connection with your case against Arun Shourie in the context of Ramakrishna Hegde. That's all. I'll be discussing that issue next week.
Okay. All right. Good. Look forward to it.
So friends, with this we come to the end of our part 1 of our episode on contempt of court and myth and realities. And I thank Dr. Venkat Iyer for his very informative and knowledgeable information on the issue, and Dr. Subramanian Swamy's input on this issue, which has made our viewers participate in a very lively discussion from the remarks which I see coming on our feedback. So with this, we end today's program on Nyaya Gyan Ganga, Legal Words of Wisdom. We will be having continuation of this program next Saturday at 8 p.m. But our regular Gyan Ganga Words of Wisdom will be aired on Sunday, that is tomorrow at 8 p.m. So do keep tuned in. And many viewers have been asking us, when do we start our Arth Gyan Ganga? That will be after this series is over, about 7 to 8 Saturdays more. After that, we'll be starting the Arth Gyan Ganga, economic Gyan Ganga. And we also are likely to start within a month a separate program for registered people on learning of Sanskrit online. So do keep tuned in and watch out and visit our website or follow the Twitter handle of @Swamy39 or @VHS India to get an update on our activities and for joining us or for our membership. Our website is www.vhsindia.org. So with this, we thank Dr. Swamy and Dr. Venkat Iyer for this interesting episode on the contempt of court. Thank you, viewers, and I thank my co-host Ramesh Swamy and the technical team for their support as usual. Jai Hind, Dhanyavad.
Thank you.